Also, our April CEs will be held in person in both Redbud and Highland on April 17th. Leslie Petke will be presenting at Highland Area Senior Center from 11 a.m. to 1 p.m. on the art of empathy through the lens of people living with the disease and their loved ones. Also, Dr. Amy Rolfing will be presenting at Redbud Regional Hospital from 4:30 p.m. to 6:30 p.m. on dementia and medications, the good, bad, and ugly. Both of these in-person events are $5 to attend, and lunch or dinner will be provided. You can sign up on hospice.org/events. RSVP is mandatory and is open to the community as well as professionals. If you have any questions, you can contact Lisa Phillipson at lphillipson@hospice.org or 618-310-7020. You can also find all of this information on our social media.
Hi, everyone. I'm Lisa Phillipson, the Community Relations Director for Hospice of Southern Illinois, and I want to take a moment to introduce my friend, Carol Sparks. Carol began her legal career devoting her time to the areas of business law and estate planning. In 2006, she had the privilege of representing her parents in the sale of their family business. Carol is deeply passionate about providing comprehensive protection planning for families and business owners. Prior to joining Beckemeyer LeMoyne Law, Carol served families and business in the Metro East as solo practitioner in Troy, Illinois, with a commitment to offer client-centered service. Looking to grow her practice and support the needs of her existing clients and the needs of those within the surrounding Metro East communities. Carol was blessed to develop a strategic relationship with the members of Beckemeyer LeMoyne Law, with whose commitment and service is intentional, relational, and client-focused. Carol continues to advise small business entrepreneurs throughout all areas of their business life cycle, from formation to future succession. In addition, Carol continues to work with individuals and families seeking to create a legacy for their families through the transfer of gifts throughout their lives and in the years beyond, those responsible for the administration of that legacy. We want to welcome Carol. Carol, thank you so much for taking the time to present this obviously important information. So Carol, it is yours. If anyone wants to write anything in the chat, we will keep an eye on that. And again, I invite you to please put your name into the chat so we can take attendance for this program. And Carol, the floor is yours. Thank you.
Thank you all. Thank you for the introduction, Lisa. It's always interesting to hear your resume read aloud, but my favorite part was the introduction as your friend. So thank you for that and the opportunity to share with you all today. Today, I'd like to talk to you all really about when to use a power of attorney for healthcare and how that is different than guardianship and how that may play in your world. I am very interactive typically when I present, so Zoom always has an unusual feel for me. So please be interactive with me. If there's questions that you have, throw those in the chat for me. And Lisa, if you can monitor those and interrupt me as needed. I do have teenagers at home, and so I'm often interrupted, and I actually have two of my dogs with me at work. They come with me every day to work, and sometimes they interrupt me. So I'm hoping that they won't interrupt our time together today. Let's get started today. And really, I want to start with this baseline of this rule under the law that once a person reaches the age of 18, they are presumed competent to make decisions for himself or herself. So by a show of hands, if you can access your raised hand feature on Zoom, show me who has children at home or who has raised children from a minor into adult. Oh yeah, here we go. Here's some raised hands. So we have minor kids at home, or we have watched our minor children come into adulthood. Yes, thank you. keep that in the back of your mind for me today as we chat, because I can tell you my oldest is 18 and just turned 18. And so one of the conversations we've had in our own home is that I can no longer make her healthcare decisions for her. And I can no longer make her financial decisions for her without her agreement, right? Without her consent. And what consent typically looks like is what we call advance directives under the law. So you're going to hear me use that terminology today. And I do want to say that, and we can all laugh about this and throw this in the chat if you agree with me, that just because your child has reached the age of 18 doesn't make you feel like they're actually competent to make some of these decisions on their own, right? So the presumption of competency is something that we're going to talk about today, and how the law really does favor the belief that all people should have the freedom to make decisions for themselves, provided that they don't have a disability that prevents them from being able to do that. Okay. So, what's our best case scenario, right? Our best case scenario in terms of how do we provide care for people who may have a diminished capacity as things age over time, or whether or not someone has a disability. Our best case scenario is everybody has their decisions written down and they were able to make those decisions for themselves, right? And remember that that's what the law sort of implies here, okay? And so the law and the practical implications of medical decision-making both favor what we call advanced planning, these advanced directives, right? Advanced directives allows people to have prompt care, relief, financial peace of mind without time, cost, and stress of court proceedings. It allows a principal. You'll hear me refer to individuals as principals when we're talking about the power of attorney for healthcare, and you might hear me refer to them as a ward when we're talking about guardianship, but both mean the individual being cared for. Okay. And so in a situation where a person is using advanced directives, that person gets to exercise self-determination about their personal health care. And this goes a long way with protecting a person's mental health. I think recent research that I read showed over 20% of medical treatment involves mental health treatment. And so this is a very big part of the law and how to protect it. And as we talk today, you're going to see that we do have some limitations with respect to a guardian's ability to exercise decisions with respect to mental health. And so preparing an advanced directive allows someone that control, okay? Advanced directives are not subject to change unless, of course, by the decision maker themselves, which basically means that once a valid directive has been executed, the court will honor it, provided, of course, there's no misconduct and the agent carrying on the duties continues to perform in good faith for the person, right? And so again, and I'll repeat this over and over with our time together today, that the law favors a power of attorney over guardianships for many reasons. Okay. Number one, the court doesn't really like to intervene. So it's not going to change when someone has already made a decision on their own. When we start to compare the two, and we'll finish kind of there today, but when we're comparing the two, I want you to know that the power of attorney for healthcare is the broadest direction that we can give. And guardianship is really the second broadest. There are other ways in which we can get people to act on our behalf with respect to our medical decisions, including surrogates. But today, I'm really just focusing on that healthcare agent appointed under an advance directive, and then that guardian who is appointed through the court process. Okay, so getting into the power of attorney for healthcare. This is a statutory form. Everything is derived from statute. It was revised in 2015. The statute allows us to appoint one person at a time. Okay. The agent has to be over the age of 18 and can't be a healthcare provider of the principal and can't operate the facility that a person may reside in. Okay. When you appoint an agent over your healthcare, you are giving that person the ability to decide to accept, withdraw, or decline treatment for any physical or mental condition of yours, including a life and death decision. So this is really our medical decision. That's the broadest scale. And you're going to hear us compare that to the plenary authorization and scope of a guardian. Okay. They can agree to admit you to or discharge you from any hospital, home, or other institution, including a mental health facility. That mental health facility component is going to be different when we talk about guardians. Your agent will have complete access to your medical and mental health records. They're permitted to share them with others as needed for your care, including after your death, to carry out plans that you have already made for yourself. And to the extent that you have not made certain plans, your agent is tasked with the decisions regarding your body or remains, including organ, tissue, whole body donation, autopsy, cremation, and burial. Under the document itself, the form allows everyone to decide when they want that agency to start. And so the first option is to make decisions for you only when you cannot make them for yourself, and the physician taking care of you determines when you lack this ability, or in other words, at the point in which you become incapacitated. Okay. And so that inability to make decisions for yourself is going to relate very closely with disability under the law for when a guardian can be appointed. Okay. To the extent that you don't pick or select the next two options, this is the option by default under the form. So if you don't initial anywhere on the form, then this option 1 is what applies under the law. Option 2, to make decisions for you when you cannot make them for yourself. And of course, the physician taking care of you will determine when you lack this ability, but also for now. You are granting access to your agent, or for your agent to access your medical plans and decisions and your medical and mental health records, okay? So that they can learn and communicate with your providers. They can participate by asking opinions of your physicians, including when they will then step into their role. Okay, so they can ask and have the ability to ask that physician to go ahead and render now that opinion when you can no longer make decisions for yourself. And then option 3 is to make decisions for you starting now. and continuing after you are no longer able to make them for yourself during this period of time, you can still make decisions as you would like to. I have clients who always ask me, how do I know what I want to choose in this moment? And I'm sure you all can share many stories with me as well. But in my experience, what I have seen is that when a person is no longer wanting or desiring to make all of their medical decisions, they know it, and it's like a light switch, and it doesn't go on and off, and it's not really like, well, today I feel like making my decisions, but after lunch I might not. It is I no longer really want to make all of my decisions, and really what I want is some assistance in making those. When I meet with clients, I tell them that if we're there or if we're almost there, and if we have a trusted person, option 3 might be the best option. Option 3 is often the best option for clients who have had a terminal diagnosis, who are going to undergo treatment, and they know that their health is going to decline rapidly. And so that person can come along and ask questions of the doctors and can help make medical decisions, schedule appointments, and all of those things that will allow them to focus really on their treatment and their health. Okay. Again, as you have questions, please feel free to put those into the chat. Duties. So the agent always has the duty to act in good faith for the principal's benefit. Failure to do so means that that person can be removed. Okay, and that would be a court proceeding to remove that person, at which point then the successor would be appointed under the document, provided that the successor also meets the qualifications. But if there is no successor, then that's where the court can look to appointing a guardian in absence of a named person under a document. Okay. Your agent is required to use due care and competence and diligence. In other words, it's their job to ask questions. It's their job to make sure that the medical treatment, the care that a person is receiving is their best, in their best interest, right? Will be a treatment that they desire, and will be care that will work in their favor. The agent is tasked with keeping a record of all significant actions, and I tell clients to do this anyway. It's a matter of safekeeping. What have I done versus what have I not done, and this might just mean keeping a notebook. I took John Smith to the doctor on March 19th. And we met with Dr. Jones, and here are the things that we discussed. Here are the course of care he's recommending, and here's how Mr. Smith felt about it. Okay, those are all things that can be documented and should be documented. Okay. Other questions that typically come up from my clients. Should I give a copy of my power of attorney to my doctor, to my healthcare provider? Yes, yes, and yes. I tell everyone, and I provide my clients with electronic copies of their documents, along with multiple copies and originals. I tell them, take that electronic copy and upload it to your MyChart, but to all of your MyCharts, right? And as healthcare providers, you probably know what I mean when I say that. Uploading it to one MyChart isn't enough. And so as healthcare providers, I'm going to ask from a practitioner standpoint that this is something that you also talk to your patients about. Have you uploaded your documents? Have you uploaded them to all of your my charts? Do all of your providers have copies of your documents? Which is a great thing in the moment that, again, they have capacity. When they no longer have capacity, that's when everybody needs to know, who do I talk to, right? How can I facilitate the best transition of their care by getting the right people involved? Clients also ask me, are my doctors required to comply with my decisions made by my agent? Everybody has a horror story. I've heard this, I've heard that, and I reassure everyone, yes, your doctors are required to comply with decisions. Now, as healthcare providers, I want you to know that to the extent that you are not comfortable with a decision made by an agent, you do have the ability to transfer care. You don't have to comply. You can say, I can't comply for personal or professional reasons. Here's my recommendation. And my advice is that we transfer care, right? And so making sure that that happens exponentially so that there won't be any delay in the care received. Can my power of attorney be ignored? Is another way people ask me that question. Can it be ignored under the court, right? Can someone come to the court and say, well, we want to appoint a guardian. We want to we want to ignore this directive that was made. And as I've shared, the law favors this advance directive. And so the court will not ignore it. However, the court may appoint a guardian to exercise authority for anything that's not covered. So there are ways in which these two processes really work together. Okay. Before I switch gears and talk a little bit about the guardianship process itself, are there any questions related to the advance directive piece of that? I'm trying to peek in the chat here. I don't see anything. Lisa, are we doing good on?
Yeah, there's one question on here that said, anytime could you differentiate between the power of attorney and the durable power of attorney? That's the only question listed so far.
Sure.
Carol.
So the word durable means springing, right? Let me back up. There's two types, and we have two states here. So most of us are familiar both with Illinois and Missouri because we cross the river for medical treatment, right? And so there is a little bit of a language that's not seamless, which creates a little bit of confusion. So let's talk Illinois first. In Illinois, we refer to both a power of attorney for healthcare and a power of attorney for property. Okay. Under the Illinois statutory forms, we have the ability to choose when we want something to begin, including today, being effective immediately, or during that future event. Okay. In Missouri, they refer to documents as a durable power of attorney, which really means that unless otherwise stated, it is a springing power, okay, which means it's not effective today. It has to spring forth later. So it's mostly a difference state to state in what you're hearing, okay? But both states have the same breadth of the agency. So the agency can start now or can start at a date in the future, okay? Missouri documents require that if it starts now, you have to put in your documents that says, and it doesn't terminate upon my incapacitation in the future. So it starts now and continues even when I'm no longer able to make decisions for myself, okay? hop on that chat if I didn't fully answer that question or if I created more confusion. Happy to continue that, or any other questions related to power of attorney. All right, well, we're going to move on. I can always backtrack if you think of something as we go. Okay.
Carol, there's no other questions, so you're good right now.
Okay, perfect. Thank you, Lisa. All right, so guardianship. What is guardianship? Guardianship is a court-appointed process. Guardianship, the appointment process happens under the Probate Act. Okay, a lot of people refer to probate and they think of the administration of assets after someone's death. Okay, probate is really just the court process where it has to take action on behalf of someone else when they can no longer make these decisions. So during their incapacitation, if they have, of course, a disability, right? Or after their death. Okay, so probate is where we are when we have to ask the court permission, right? And to do that, we file with what's called a petition. And that petition has to really show the court with great evidence that they need to act. Remember when I said that the law favors the advance directive, the law presumes that if a person is over the age of 18, that they have the ability to make their own decision. And not just the ability, they want to protect the freedom that comes with making one's own decision. Okay. And so guardianship, when the court looks at it, they start to say, okay, when will we appoint a guardian? And the law says, well, when it's necessary to promote the well-being of a person with a disability. So we'll talk about what really is a disability. To protect that disabled person from neglect, from exploitation or abuse. So that's another standard. We'll kind of get into those. But guardianship will always be limited to the extent necessary to encourage the development of the person's maximum self-reliance and independence. So that process, even the way the process is described, has limits within it. So the first thing that the court has to determine is this person disabled? Okay. A person, a disability, right, under the law means, of course, the person has to be over the age of 18. We've talked about that. And they have to be found conclusively to be disabled because of mental deterioration or physical incapacity, where they are not able to manage their person or estate. It doesn't have to be both. It can be one or the other. Or a person has a mental illness, or a person has a developmental disability, and I italicized and, because the court has to say because of that illness or disability, they are not able to manage their person or their estate. A disability alone does not mean you need a guardian under the law, okay? There's another caveat, right? If a person is found disabled because of gambling or idleness or debauchery or drug use and abuse that's harmful to himself, his family, or a person who has been diagnosed with fetal alcohol syndrome or fetal alcohol effects. I'm really going to keep us under A and B today for our conversation, okay? So how does the court really determine and apply that definition of disability? Well, first of all, it is a very fact-intensive inquiry. you could have two individuals, almost identical facts, and the court can come to two different conclusions, right? And so that's where we're at. We are in a world of gray here. And again, because the court is making sure that this is necessary. The court is asking, is this person able to make or communicate their decisions? Can he or she make a decision, all right? Can they manage their decisions? Two different inquiries, okay? Where a person can make a decision, the court wants them to make that decision. If they need assistance to carry out those decisions, then the court may appoint a guardian limited in scope. You can do A and B, but this person still has a right to make his or her decisions. Okay. A person can be capable of making a healthcare decision or a decision relating to their estate or vice versa. Again, these are separate inquiries before the court. And troublesome at that, right? And in my experience, what I've seen is that inexperience or lack of capacity or lack of ability to manage your estate happens separately and often happens more than having someone not able to make their own medical decisions. So in this world, in your world, it is a very heightened threshold of whether or not the court will take away someone's ability to speak for themselves. Okay. Some good examples of this. Dementia, having a diagnosis of dementia does not necessarily mean that a person cannot make a decision for themselves. Okay. When I do planning for clients, we utilize a standard for testamentary capacity. And really that is, does this person know what assets they have and who they want to give it to? And there are, there's a lot in terms of ethical considerations that we have as practitioners and working with clients with respect to that. But the diagnosis of dementia alone does not mean a person requires a guardian. Same for Down syndrome. One of the things I've seen, unfortunately, I had a phone call a few weeks ago. A colleague of mine had been working on an injury case, and the victims in the case were awarded a settlement, and they were all nonverbal, wheelchair bound, twin brothers, 30 years of age, and mom had been doing everything for them. And somehow, in some way, shape, or form, and this is a Missouri client, so maybe things are happening different in Illinois, but I wouldn't presume that. Some way, shape, or form, this family had not gone through a guardianship process, and mom had been able all the way up to age 30 to take care of everything that these boys needed. And now became the time that they needed to sign a settlement, and she didn't have the authority to sign that. And, she's asking herself, why not? I've done everything else for them. Similarly, I had a client whose son has Down syndrome, and she's provided his care all of his life. And now he's 18 years old. And the thought had never even crossed her mind that she would not be able to continue the care that he needed simply because he had another birthday. And so as practitioners, these are other things that I'm begging of you to have good conversations with families on, because the law sometimes can come to people as quite a shock. And the law can feel very rigid and offensive in these situations, especially when families are just trying to care for their loved ones. Let's see. Ooh, I hit the wrong button. Bear with me. Again, courts are looking at each individual to gather information and to make inquiries on this. The threshold for capacity to be able to prove that one no longer has the ability to make their own decisions has to be proven by clear and convincing evidence. Okay. Now, that might not mean a lot to you, but under the law, that is the highest threshold of proof. And so when you think about a typical vehicle accident, did person A run a stoplight? Okay, that is by a preponderance of the evidence. Does it look like that happened? Could you reasonably assume that happened? Okay, by clear and convincing evidence, puts the court in a situation that they say, is there any other conclusion that can be drawn except for this one? That this person no longer has the ability to make decisions for themselves. So I hope you feel that difference of threshold under the law. Okay. All right. Who can be a guardian? Remember that I said that a person under the power of attorney, for healthcare, that agent can be 18 years of age and they cannot be a healthcare provider. The standard for guardian is a little bit different. 18 years of age, yes, but they have to be a resident of the United States. Why? Because they have to be subject to jurisdiction of the court. Okay. The court will qualify them. So the court has to be able to say that they are not of an unsound mind, that they do not have a disability themselves. Okay. There's also a qualification for all agency under a court appointed that a person cannot have a felony conviction. Now, I can tell you that there are cases that go round and round and round about this. So let me give you an example. Mr. and Mrs. Smith have been married for 50 plus years, and Mrs. Smith is dying, and she consents to her husband, Harry Smith, coming in and being her guardian, and she participates in the process, and she says yes to the court. Yes, I want Harry to be my guardian. And Harry has a felony. Okay, and so the court has a question to ask. Was the felony related to an abuse type of a crime? Okay, and so the court can look and limit their scope to that. So we do have some appeals courts that say, hey, that, Mrs. Smith has the right to choose her husband, and to say otherwise would be to take away a right that belongs to her because his felony, for example, was not an abusive type of a relationship. Okay. So can family members be guardians? Yes. Can friends be guardians? Yes. Can unrelated people that don't know the ward be a guardian? Yes. And there are processes for that. There are organizations that have groups that hire healthcare professionals like yourself who can come in and ask good questions and care for people in these situations. And so calling on healthcare professionals like you to step into these roles. And the state also has its own division for anyone who can't afford a guardian but yet needs one. Okay. Types of guardians, right? So, and we talked about this, and let's do it in opposite or in reverse order. So, a temporary guardian, what's that? That means an emergency. Someone has an emergency or a limited duration of a need, okay? A limited guardian, that means not all decisions. A plenary, that means general. That means the broadest type of guardianship that the court allows. Okay. So what does that mean? If we're assuming that a person has general guardianship, what does that look like? And here's the key. Remember that the guardianship process is overseen by the court throughout the entire process. Okay. And so the powers of the guardian arise statutorily under the Probate Act, but also have to be documented by court order. Okay, so the court order has to say what powers that guardian has. A general guardian will typically have custody over the person and any of that person's minor children or adult dependent children. Okay. That guardian is responsible for providing for, this is where we call it a HIM standard. So health, education, maintenance, support, professional services, right? The guardian, again, their scope is limited to the extent that the ward or the individual is able to make decisions on their own. So the court will scale back anything that they can in order to maximize that independence and ability to make one's own decisions. When the guardian steps in, there are two different thresholds of decision making. So the first threshold is called substituted judgment. Okay, which means that the guardian is stepping in for a person and should make decisions for them in the way that they would make them for themselves. So the guardian is required to look at things such as what that person may believe, what are their philosophical, religious, moral, ethical beliefs, what treatments or care would they be opposed to, what things would they be in favor of. Now, does a guardian always have to follow that substituted judgment? No, because sometimes that judgment, that knowledge is unknown. So to the extent that the individual's wishes are unknown, then the guardian acts in the best interest of the person. Okay. Also, to the extent that what someone may choose for themselves may ultimately be harmful for their well-being, or for one of their minor children or adult dependent children, then again, the guardian can do something different. Now, a prudent guardian would go back to the court and say, this is what the ward wants or the individual wants, but here is what I intend to do, and this is why, right? And so the guardian is always applying the balance of what's the benefit and what's the risk, okay, of every action and decision that they make, right? And so how do they make those decisions? Because remember, their broad ability to make those decisions is similar to that power of attorney for healthcare, right? That agent who has the ability to make all decisions related to medical treatments. These include anything from vaccinations all the way to life-sustaining treatments or life-ending treatments. Okay. And so the guardian has a duty to be informed, just like that agent under the power of attorney for healthcare. The guardian has to know as much information as possible on each and everything that they say is in the best interest of the person. Okay, especially when you have someone who is not consenting. So there will be times in which a guardian is appointed over a person and the ward is not consenting to a particular treatment because their judgment, right, may be impaired. They don't have the capacity to make that decision for themselves. And the court has said, okay, you aren't able to make that in your best interest. And so we're going to have someone else make that decision in your best interest. And so again, that guardian has to be informed. Knowledge is power. Yes, the guardian always has to follow the ward's instructions, again, to the extent that it is not harmful, right? So their duty of care requires that they have to go, wait a minute, that could hurt you. That's not in your best interest. And so when they see things that might not align, they have a duty to act early. Remember, the court is involved, so go to the court early and often to the extent needed. Okay. Now remember, we talked about under the power of attorney for healthcare that the agent under a power of attorney for healthcare has broad power, right? They can agree to admit you to or discharge you from any hospital, home, or other institution, including a mental health facility. So that's called residential placement. That is not something that a guardian has unless it is in a court order. Okay, so that's just something that needs to be put in every court order to the extent that it's necessary. And again, the same inquiry that the court is going to ask is going to apply. Is this decision necessary for the well-being of this person? And does this person have the ability to make this decision on their own? Okay. A guardian outside extraordinary circumstances does not get permission to consent or to authorize medical treatment for individuals. Remember early on, I told you that over 20% of every medical decision and treatment includes mental health. That is a big limitation that a guardian has, whereas a power of attorney for healthcare does not. Okay. And so anytime there is a medical treatment or admitting someone into a mental health facility, that is where the ward has to consent. Okay. Now there's avenues to get it absent. Okay. And I will tell you that there are ways to get it, but again, the threshold is very high. So here's an example that I want you to work through with me as practitioners. Know that a court order could allow a guardian to place someone into a skilled nursing facility, right? And they're there and things are going good and you're able to treat them and care for them. And all of a sudden their behavior, maybe due to dementia, maybe due to other factors, becomes such that now there is a recommendation to move this patient from where they are within that skilled nursing facility into a unit, like a behavioral unit within that facility, okay, for medical health purposes. This cannot be done absent court order or consent by the ward, okay? All right, so a little just comparison of what we've talked about today, right? So we have our agent, this is under our advanced directives, okay? Our individual appoints that person, okay? The guardian is appointed by the court with the consent of the ward, okay? Both can make medical decisions. Only the agent, absent additional court direction, can admit a person to a mental health facility. And only the agent, absent court directive, can place someone into a residential facility. Okay. So they're different, but can they work together? Yes. When a valid agency exists, so someone has done their advanced planning and they have an agent working on their behalf, remember that the court cannot appoint a guardian who has powers similar to that agent, provided that that agent is performing in the best interest of the person, right? But if they're disqualified, that's when the court can act, right? First goes to the successors. If there is no successor or they run out of successors, then the court can appoint someone different, okay? And additionally, that agent under that healthcare directive can be the guardian. And oftentimes, and in my planning, it says that if a guardian is required to be appointed, make it this person, still make it be my person. So to the extent that there is some authority or power that someone needs, and the court says, nope, it has to be done by court order, then together, allowing that text within the power of attorney for healthcare, a petition can be brought to the court to say, appoint this person as my guardian and let them do whatever else is needed. Okay. So I know I threw a lot at you. I know they're all concepts that you're familiar with, but I wanted to really break them down for you today and show you how they work exclusive of one another and then how they work really together. Again, it is such a it is so important that planning be done in advance to the extent that people are able. So encourage people. It's a difficult process for some, but it doesn't have to be, right? So
Carol,
that's it.
I do have a few questions.
Yeah, ask
So
away.
the first one is, what does, in quotes, deemed incompetent mean on the power of attorney? What does that mean?
So the language under the power of attorney is really the same standard. So it's not incompetent is not the word. It's the inability to make decisions for themselves, right? And the physician is the one who determines that. So it's really that same standard. You're going to see that same standard under the law, whether it's under the power of attorney, whether it's under the surrogacy statute. Or the surrogate statute, or whether the court is looking at it from a disability standpoint.
Got it. And the next question, how do you terminate a guardianship when family requests not the resident to terminate? What is that process?
You have to go back to the court. Okay. So, and that, it's hard to get appointed, also hard to get revoked. Okay. So a revocation under a power of attorney for healthcare under that advanced directive, that decision maker, as long as they can make those decisions for themselves, they can revoke it in a lot of different ways that are so much easier. But the revocation of a guardianship has to go back to the court. And a guardian ad litem is always a part of this process. And so that's a person, typically a licensed attorney, that comes in and speaks on behalf of the individual whom a guardian is being appointed. So that person that is ultimately appointed guardian, they're not there to speak on behalf of that person yet. Okay, a guardian ad litem is, and the guardian ad litem is going to tell the court what they want and what they don't want. And so the same is going to come into play with that revocation.
Got it. And the last question, can a power of attorney healthcare refuse to allow a resident in a nursing home to visit with a person or go on an outing?
Yes,
Yes, okay, that's.
under
with the
both. Yes,
Under-
the agents have the ability to make decisions in that way. Okay.
Okay.
So
That's easy. All right, I'll just double check to make sure. Okay. And you guys, everybody has in their email, they are in this chat, they are able to get their CE information filled out. And this is Carol's information. If you would like to write it down, please do. Carol, thank you. The information was absolutely what we all kind of need to know, and you know, and you never know when you might need to use the information. We also want to thank everybody for coming on today. We want to remind you that we have the 2 upcoming CEs on the same day, one in the afternoon and one in the evening. Afternoon is in Highland and the evening is in Redbud, and these are in person. But the only thing mandatory about them is you must RSVP for them because we're going to have lunch and dinner with those. We want to offer everybody a beautiful week next week. And if you celebrate Easter, we want you to celebrate that with your family and loved ones. And always remember, for Hospice of Southern Illinois, we're a standalone hospice program, and we invite you to ask for us by name. Thank you, everyone, and wish you have a great afternoon. Thanks,
Thank
Carol, so much.
Yeah,
Thank you
thank
so
you.
much.
And happy
Thank you,
first day of
Carol.
spring to everyone.
Yes, and April 4th, home opener.
That's right.
Thanks, everyone. Thank you, Carol.
Yeah, have a wonderful day.
Thanks. Okay. See, we got this.